Hello there, and welcome to this bite-sized revision video on the first data protection principle. The first thing to start with is, are you processing personal data? If the answer is yes, then GDPR applies to you and the requirements of the GDPR apply as well. With that comes the 7 principles, 7 basic rules for how you use and manage personal data. Also comes the data subject's rights and other things, including the fee. But we're going to focus on, for the purpose of this video, the 7 basic principles, and they are as follows. Principle number 1. Information should be processed fairly, lawfully, and in a transparent manner. Principle number 2. Information should be collected for specified, explicit and legitimate purposes, and not further processed in a manner that is incompatible with those purposes. Principle number 3. Information should be adequate, relevant and limited to what is necessary. Number 4. Accurate and where necessary kept up to date. Number 5. Kept in a form that permits identification of the data subject for no longer than is necessary, otherwise known as the data retention principle. Principle number 6. Ensuring that the information is processed in a manner that ensures appropriate security to protect its confidentiality and integrity, otherwise known as the security principle. And principle number 7. The accountability principle, ensuring that you are able to demonstrate compliance with these requirements. We're going to focus on principle number 1. Lawfulness, fairness and transparency. Principle number 1 says that personal data shall be processed lawfully, fairly and in a transparent manner. So let's look at the lawful part of that. What this says is that if you want to use personal data, so name, address, date of birth, that sort of thing, then there are 6 different ways that you could potentially do it based on your purpose. The first, and this is in no particular order, just the way that they are listed, the first is the data subject has given their consent. Or it could be necessary for the performance of a contract that you have with the data subject. It could be part of your own legal obligations, so if the law says you must have it for X or Y or Z reason. If it's to protect the vital interests of the data subject or of another person, so for example they are in danger and you need personal information in order to support them. If it's for the performance of a task carried out in the public interest or in the exercise or official authority vested in you as a data controller, or if it's necessary for the purposes of your own legitimate interests, where it's subject to a legitimate interest test. Now most of these you can find defined in the GDPR. However, number 5 is specifically as in further detail in the Data Protection Act 2018. What that says, specifically section 8, is that for the performance of a task carried out in the public interest or in the exercise of a controller's official authority includes things like the administration of justice, the exercise of a function of either Houses of Parliament, the exercise of a function conferred on a person by an enactment, or an exercise of function of the Crown, a Minister of the Crown, or a government department. Therefore, especially for C, unless there's something specifically conferred on you or your organisation as part of an enactment or in British law, then you cannot use it. Let's go back to the 6 grounds of processing and look at consent. Consent is one of the areas in GDPR that changes in GDPR. It is a little bit more stricter and there are some things to remember. So, first of all, your consent must be unbundled. Consent requests must be separate from other terms and conditions, and consent should not be a precondition for signing up to a service unless it's necessary for the performance of that service. Someone must actively opt in. Pre-ticked boxes are invalid. It's got to be specifically opt-in boxes where someone does something. They say yes or no, they sign something, they tick something, whatever it might be. Has to be granular, So you have to give granular options to consent separately to different types of processing where appropriate. So if you want consent for 3 different things that all might be part of the same service, then you might need to get 3 individual consents. You have to name who the consent relates to, so the organisation or any third parties that will be relying on that consent. You have to keep a record and keep it documented, who agreed to what and when and how. It has to be easy to withdraw, and you've got to give people a way for how they can withdraw that consent. Also means you have to have mechanisms in place for them to do it, and a mechanism for deleting that data once they say that you're no longer allowed to have it. There should also be no imbalance in the relationship between you and the data subject. Consent must be freely given. Therefore, if there is an imbalance in the relationship, it is not said to be freely given. That's why it's often said that for public authorities or even employers, especially in the context of employment and employers, that an employer cannot really obtain a freely given consent, especially if it relates to that particular role. If you then want to use special category data, so anything that includes genetic or biometric data, health data, details of sex life or sexual orientation, racial or ethnic origin data, political opinions, religious or philosophical beliefs, or trade union membership, then it's all categorized as special category data, and for this you need something from Article 9 as well as something from Article 6. Article 9 says that you will not use this data unless you explicitly meet one of these areas. That could be that you have the person's explicit consent. It could be that there's something in employment law in the United Kingdom that allows you or gives you the power to do it. It could be that it's part of a health or social care reason or delivery of health or social care. It could form part of a legal claim. Or it could be something where there is a substantial public interest to do so. Now, this is not open to interpretation. This is something that's defined in the Data Protection Act 2018. You'll find in the Data Protection Act 2018, specifically Section 10 and Schedule 1, further details for things like employment law, social security law, substantial public interest, health and social care laws, public health and archiving research. It makes the definitions British. Therefore, if you don't meet the definitions as defined, you can't use it. It's not open to interpretation. Under substantial public interest grounds, that's defined in the Data Protection Act, Part 2 of Schedule 1, in there it says these are the different things that you can justify as a substantial public interest. Parliamentary and statutory government purposes, the equality or opportunity of treatment of individuals, preventing or detecting unlawful acts, protecting the public against dishonesty, disclosure for the purposes of journalism, counselling, political parties, and sharing and working with elected representatives. If you are going to use the substantial public interest grounds of processing or the employment and social law grounds of processing, the Data Protection Act 2018 also requires you, in Part 4 of Schedule 1, to ensure that you have an appropriate policy document in place. This requires you to outline pretty much everything that's in a privacy notice, but specifically outline how you're going to use personal data in accordance with the principles, especially the sensitive personal data that's here. If you're using any other grounds of processing, either just in Article 6 or any other part of Article 9, then one is not required. It's only required if you're using either one of these grounds of processing. Or you can have a look at many organisations' templates and things they've published in the public domain for examples of how different organisations have approached it.